Okay, we're going to start. Thank you everybody for showing up to our first book talk of the second semester. I have the honor of presenting our author for today, Professor Neil Richards from Washington University in St. Louis. He has just published a book with Oxford Press, the title of which is Intellectual Privacy, not property, but privacy, a very provocative title. And I'll just give a brief bio of Professor Richards before turning it over to him and allowing him to give his book talk. Actually two housekeeping matters. Feel free to get up to get more pizza at any point during the talk. Secondly, we will have a book signing at 1 after the talk is all over. We have copies of the book, and Professor Richards will be signing the book, so feel free to stay for that. If you need to leave but want a signed copy, just let somebody know here at the right here in front that you want to purchase a copy, because we'll have them also in the bookstore down in the concourse level. Okay, so Professor Richards graduated from the University of Virginia Law School, correct? Where he also got a master's in legal history. He then clerked for Judge Niemeyer on the Fourth Circuit, and afterwards with Chief Justice Rehnquist on the Supreme Court. He practiced at Wilmer, Cutler, and Pickering in D.C., specializing in appellate litigation and privacy law. He is an internationally recognized expert in the fields of privacy, First Amendment, and information law, which all relate to the topic of his book. So without further ado, Professor Richards, take it away.
Thank you, Ed. It's great to be here. This actually is that the book was officially published in early January. Although I've learned there's like the publication date, and there's the release date, and there's the date you actually can buy copies in the store. And it's all very complicated, but the book is now available. It's been about on and off about 10 years of my life thinking through these questions, and I'm delighted to talk about them. This is actually the first time I have talked about the book since it has been published. And I'm really glad you guys could all come, especially including some old friends and former students as well. So thank you. So remember these. I'm 42 years old, and I am just old enough. The very first term paper I wrote in 6th grade, it wasn't on this typewriter. I would have been mortified using a pink typewriter at age 11. But the very first term paper I wrote was on a typewriter. I'm just old enough that I could have used such a thing, and just young enough that I could have had such disgust at having to use something you couldn't edit. And so I cajoled my parents using arguments about that they want me to be a good student and be successful academically, and it seems to have worked. But I got them to buy me a word processor, and I think that's an important switch, right? The switch from typewriters to word processors, the switch from paper to pixels. So for hundreds of years, the technologies we have used to communicate have been based upon paper. With the letter, we have the newspaper, and we have the book. But in our lifetimes, these technologies have been supplemented and increasingly supplanted by digital electronic versions, the email, the web page, and the ebook. I think this is significant. I mean, these technologies are tremendously useful, they're tremendously powerful. They let us do lots of new things. But at the same time, they're also engineered by design to create a detailed track record, a detailed history, a detailed observations of the ways we interact with them, what we read, when, how long, how many times. They enable us to express ourselves. Right? Anybody with a smartphone, anybody with a laptop can start a blog and write in a format that anybody else, at least in Western countries with freedom of speech without firewalls, right? Anybody else can access their musings, no matter how powerful, no matter how subversive, no matter how trivial. That's a huge win for the freedom of speech. At the same time, it also raises questions of privacy, of the monitoring, the tracking, the surveilling, not just by in the aftermath of Laura Poitras' win at the Oscars last night, right? That not just by the NSA, but also by private corporations. And that's what I want to talk to you about today. So this is a famous cartoon that used to get trotted out all the time whenever people talk about the internet or privacy. This is from 1993, and the caption says, on the internet, nobody knows you're a dog. The idea being that on the internet in the 1990s promised this wonderful field of anonymity and privacy. It was a completely private platform where anybody could read free of monitoring, free of constraint, free of interference. The New Yorker ran a sequel cartoon last week, which has the same two dogs, and the dog is saying, remember when on the internet nobody knew who you were, right? And again, right, I think being as old as I am, right, I've been an adult for both of these phases of the internet, the privacy phase and the surveillance phase. And what this means is we have a story we need to tell, we need to figure out about technology, but it's also a story about human values, about how we can get the values that we want into our technologies, rather than having our technologies dictate to us what our values are. So my book is about two simple ideas. There's a lot of complexity. I'm a law professor, right? That means things are really simple. But the first basic idea is that when free speech and privacy conflict, free speech should usually win, should win most of the time. Second idea is that free speech requires something that I call intellectual privacy. Well, what is intellectual privacy? Well, it's the title of the book, so I should probably explain that at this point. Intellectual privacy is what the dogs had in 1993, but is not what dogs have today. Of course, right, we're the dogs. It is the protection from surveillance or interference when we're engaged with interacting with the world and generating ideas, thinking, reading, and speaking with confidence. It's what happens, it's what you need in order to read books, either by purchase or from the library or on the internet, freely, in an uninhibited way and without constraint. Let's talk about the first idea. This is Mabel Bayard Warren. So privacy in America, just out of curiosity, how many people are lawyers here? So a fairly large group. Or maybe some shy lawyers aren't raising their hands. But many people think that the story of privacy in America begins with Warren and Brandeis, right? Lewis Warren, the first Jewish American Supreme Court justice, his law school roommate and best friend, Sam Warren, who is the heir to a Boston paper company. They actually begin with this woman. This is Sam's wife, Mabel Bayard Warren. There are not that many pictures of her that survive. This one was a charcoal sketch made for her by Henri Matisse, which should tell you something about the level of wealth that Bayard was privy to. This is when she went on her grand tour as a widow later in life. This is Mabel. Mabel in the late 1880s was beautiful. She was sort of the star of the Washington Sociality. She was the daughter of a senator Senator Bayard from Delaware. She married Sam, the heir to this Boston Barometer publishing fortune. The Washington Post covered their wedding on the front page. They called it the social event of the season. Ambassadors and politicians attended. Bayard was beautiful. She was charming. She was vivacious. She was rich. She was also deeply anti-Semitic and deeply proud. When she married Sam, Lewis, his best friend, was not invited to the wedding because Lewis was Jewish. Mabel and Sam moved to Boston, continued their extravagant social life, held great parties. Lewis wasn't invited because he was Jewish. But the Boston press started to cover the stories. They started to report upon who was going to the Warrens' dinner parties, and Mabel, proud as she was, elitist as she was, got angry. Someone should do something about this. And so she said, Sam, why don't you try and change the law? Well, Sam had written a series of articles on pond law, right? The law of big puddles, with his law school roommate Lewis. And I think that they needed an excuse to be able to play together, since they couldn't hang out at Sam's house anymore. And so he enlisted his former law school roommate, Brandeis, Jewish from a second-generation German immigrant from Louisville, Kentucky. graduated first in his class at Harvard with grades that wouldn't be duplicated in his lifetime. Sam graduated second in the class. Together they wrote an article, which is the most famous article in the history of law reviews, Warren and Brandeis, The Right to Privacy for Harvard Law Review 193, 1890. It argued that something should be done. And what it argued was that the common law should protect ordinary people whose dirty laundry gets aired by the press by a cause of action where they could sue them for hurting their feelings. The problem with the tort was it punished the press for publishing the truth that hurt people's feelings, right? And this is an issue that is in some tension with the First Amendment. As I said before about privacy and the First Amendment being in conflict. Later in his life, after creating the tort of privacy, Louis Brandeis was appointed by President Wilson to the Supreme Court. He began to really think about the First Amendment and actually also created what we know as the modern First Amendment, along with Oliver Wendell Holmes. So both of these ideas are bouncing around in Brandeis' head. Privacy early in his life, when he was 30 years old, when he wrote the Law Review article. And then later in his life, when he was in his 70s and sort of approaching the end of a distinguished public career. If Brandeis' relationship with privacy was defined by his relationship with Mabel Warren, his relationship with free speech was defined by a relationship with another aristocratic woman of the same social, actually a distant relative of Mabel's through their Mayflower ancestry, Anita Whitney. Anita Whitney was a West Coast radical socialist who had done her grand tour of Europe and then came back committed to problems of poverty, to the problems of racism, to the problems of workers' rights. Whitney was arrested for criticizing the government in Oakland, and she was tried by the government for criminal syndicalism, sort of basically being or teaching the doctrines of revolutionary socialism. Her lawyer died during the flu epidemic of 1918, and the trial went on, and she was convicted. The case went to the Supreme Court, and Brandeis wrote a famous opinion in Whitney v. California, arguing that we should protect the freedom of speech because it is the only thing that allows us to govern ourselves, that it is central to democracy. And these two notions are in deep tension when we think about privacy and free speech being in conflict. For example, the first problem with the old notion of tort privacy is the publication of the truth by the press. Anybody, you know who this is, but anybody know who this is? Yeah.
Brian Gates.
Brian Gates, the second greatest soccer player that Wales has ever produced. Ian Rush, who played for Liverpool, being of course the greatest, and Giggs is merely second. So Giggs was lauded, famous soccer player, same age as me, much better at soccer than me. Played for Manchester United for his whole career, just retired last year, lauded for being a model professional, skillful, intelligent, a family man. Anyone know who this is? This is Imogen Thomas, who is an English reality TV star, who Giggs would meet for sex when, not his wife, who would meet for sex whenever Manchester United played away in London. And Thomas threatened to go public with the truth of the fact that Giggs was not the role model that he thought that she was. The English press actually gagged, this is after the gag was released, the English press gagged the story. And the difficulty is, right, we use our celebrities to talk, there's some really great headlines here. There's naming Private Ryan, I think that's quite good. And I don't know if it's been taken off or not. But you know, the tabloids, of course, had a field day with this. The English press has found a right to privacy along the Warren and Brandeis lines in previous years, and they will create something called a super injunction, right? It enjoins the press from publishing the truth about famous people's sex lives. And they will even enjoin the press from reporting upon the fact that they are enjoined from talking about famous people's sex lives. The injunction covers the fact of the injunction itself, not just the facts that the injunction is enjoining. And the problem with this is we use our celebrities, we use our public officials to talk about issues, right? The Oscars were last night, right? And the lives of movie stars, the lives of directors, the fact that There was the director with Sean Penn, and the fact that he was Mexican American. Right? These are platforms for politics. Their lifestyles are platforms for discussion. One of the things the First Amendment correctly in the United States, I think, and as an Englishman, it's hard for me to admit this, right? That the English law is wrong and American law is better. It is here. Is that we must be able to talk about the truth in the press. That is truth that is newsworthy, that people use to explore these issues. Second problem with the Warren and Brandeis privacy story is emotional harm. Anyone know who this is?
Larry Flint.
That's Larry Flint, the publisher of Hustler. And Larry Flint published an article about Jerry Falwell in his famous Supreme Court case that was produced out of this. It was a fake Campari. So Campari used to have, Campari is an Italian aperitif. And they used to run these ads in which women in soft focus would talk breathlessly about their first time. My first time, it was wonderful, the sun was shining. And you're supposed to think they're talking about having sex for the first time, but it's their first sip of Campari. Well, Jerry Falwell in the ad talked about his first time, which was having sex with his mother in an outhouse when they kicked out the goat. And it was used to parody Falwell's moralistic stance on the Supreme Court, an opinion by mild boss Chief Justice Rehnquist, the only time he ever found a First Amendment plaintiff, a First Amendment claim to be appealing, said, politics is messy. Politics involves offending people. Public debate means that feelings get hurt. And basing privacy around protecting people's feelings from getting hurt, when it's something the public wants to know, is very dangerous. And this guy won, and that guy lost. This is Fred Phelps, the late unlamented head of the Westboro Baptist Church. The Supreme Court recently decided a case which reaffirmed the Snyder ruling, saying that funeral protests in designated free speech zones that don't intrude into people's spatial privacy around the gravesite are protected by the First Amendment, because if it is true that God really does hate America because of its sexual permissiveness, and he is punishing us for our libertinous nature, then that is something that we should know. And emotional harm is really not a basis for a robust theory of relief for privacy that can sustain that can survive against a strong First Amendment challenge. Third problem is the problem of public versus private. Does anybody know who this is? This is Tyler Clementi. This is the Rutgers freshman whose roommate videotaped him having an encounter with someone, a sexual encounter in his dorm room. He streamed it to people in the dorm, and then Tyler committed suicide by jumping off the GW bridge, right? Warren and Brandeis said there's a line between public and private. Some things are private, and some things are public, and the courts can figure out which is which. This was private, right? I think that the idea of sexual recording of an ordinary person is very different from the fact that Ryan Giggs is sleeping around. Video of Ryan Giggs sleeping around would be a harder case. There is a line between public and private, but if we care about the First Amendment, I think we have to draw that line very, very narrowly and only protect against publication the most horrific and most damaging kinds of injuries, like the one that happened to poor Tyler, or else we give the court the power to censor things that people want to talk about and want to read about, and that's the problem with the Ryan Giggs case, right? For better or for worse, I just learned this yesterday that Prince Harry is apparently dating Emma Watson. We use celebrities to talk about issues. We use it to talk about wealth and poverty and family and careers. In the case of Prince Harry, what the acceptable bounds of dressing like Hitler are, right? Harry is just a wonderful character for all sorts of legal hypotheticals. But this is the kind of story that Mabel would have wanted to have protected. It is the kind of story that I think if we're committed to freedom of speech, even if we care about privacy, we need to allow to run in an unfettered way. Okay, but that's not the most interesting part of the story. The most interesting idea, I think, is the second idea, that free speech requires intellectual privacy. Intellectual privacy is our ability to understand the world on our own terms, to make up our minds, to figure out what we believe when we are reading, thinking, or talking with confidence, right? If we can't come up with anything interesting to say, if we don't have this zone of exploration with ideas, all the anti-censorship provisions in the world won't do us any good. We need to generate interesting, novel, eccentric, weird, controversial, deviant ideas, or we can actually say that we live in a free society. Think about how many of our most cherished ideas were once deeply controversial, that people literally died or were burned at the stake for. Freedom of conscience, freedom of speech, freedom of thought, the equality of all people regardless of race, gender, or sexual orientation. The idea that the people should be in charge of the government rather than the government should be in charge of the people. The idea that we shouldn't live in a theocracy, that people should be able to believe what they want about the world and about the cosmos. Right? These are the ideas that were once deeply, deeply controversial. They were only able to flourish because people were able to read them, to engage with them. There are bad ideas too, right? Mein Kampf, terrible book. But you should be able to read it, and you should be able to understand it and to reject it, or if you so wish, to believe that, hey, maybe that guy with the funny mustache was onto something, right? That in a free society, there can be no such thing as a false idea. There can be such thing as illegal actions, and we can disagree with people through speech, but our minds should be free and unfettered. So there's two claims here. One is what we call a normative claim, that it's an ideological argument that intellectual privacy matters. There's also an empirical claim that surveillance chills intellectual privacy, right? So this is whenever I throw this slide, at least a third of the audience sort of recoil back. It helps if he's really big. This is a fairly small screen. We have these cultural intuitions from Orwell. If we want to go further back to Bentham, if we want to get pretentious, to Foucault, that when we are watched, we act differently, right? That we change our behavior. If the dean of the law school, who I've not met and who I'm sure is lovely, if the dean were to come in right now, people might act differently. If the governor were to come in right now, if I were being lined by a bunch of police, and they don't even have to wear the sort of scary black uniforms we saw in Ferguson in St. Louis, where I live, in order to be scary, right? But being watched inclines us to the inoffensive, the mainstream, and the boring, or at least it inclines us towards doing things that the watchers wouldn't find objectionable. There's some great empirical evidence. My favorite social science study of all social science studies comes from the University of Newcastle, where the psychology department had, being English, a penchant for tea. And they drank a lot of tea, and the tea requires, of course, as it should, milk to be drinkable. And they had an honesty box for the milk. And they wanted to figure out, and there was a sign that said, please give 25p for every, or 10p for every cup of tea that you drink. And they wanted to figure out if being watched made people behave. And so what they did is they had the sign, and they changed the background on the sign. And on odd weeks, on even weeks there were flowers behind the background. And on even weeks there were eyeballs. And guess what? On the weeks where the eyeballs were there, like these people here, there was more compliance, they were paying more money for the milk. The best thing, right, this scary vampire guy got an awful lot of things. And this guy got the best, and I believe, I need to dig into this, I believe that was Pierluigi Collina, who was the referee who suffered from alopecia, who used to referee World Cup finals, considered the best referee in the world. And actually, if that guy were reffing my soccer game, I would think twice before sliding into a tackle. So there's other evidence. One of my colleagues at Washington University found that when there's electronic monitoring on cashiers at Applebee's, they steal less, and that's good. But we've also found out, right, that stealing is bad, but believing a belief is not bad, right? There's bad behavior, but in a free society we can't have bad ideas. Some scholars out of MIT found that in the aftermath of Snowden, they found two things. People searched Google for less controversial things. They searched less for how to build a bomb. They searched less for Al-Qaeda. They searched less for dirty bomb exposure effects. They searched for all sorts of, they searched less for the TSA, which you might expect. And that might not trouble you, but they also searched less for divorce lawyer, eating disorder, alcoholism, weight gain. They searched for anything less for things that were considered personally embarrassing rather than being politically embarrassing because they were being watched. We also have the idea, and it's been a bad winter, you may have these already in Chicago. We also have the idea from First Amendment doctrine of a chilling effect, right? We care about a liberty, we care about a fundamental human right. We don't require as rigorous empirical proof in order to protect it. The NSA has been watching radicals for their porn surfing habits. Not terrorists, not people who are members of Al-Qaeda or ISIS. These are people who are merely radical, who have some sympathy with the radical jihadi argument. And this is a declassified Snowden document. The idea was, if you find out what kind of porn they like, we can use it to undermine their credibility and to undermine their authority. This is the spreadsheet of the targets of surveillance. You have clerics, you have academics, you have critics of U.S. policy, you have celebrities, you have a number of characteristics. Clerics, preachers, critical of U.S. policy, a U.S. person, a radicalizer. And you may think that sounds like Ayman al-Zawahiri, but it also sounds like this guy, who the FBI did subject to wholesale surveillance because they believed he was a communist. Turns out he was opposing U.S. policies in the South. Not because he was a communist, because he actually believed they were wrong and contrary to his religious convictions. But they found out that King was having several affairs with women not his wife. They photographed the affairs, and they sent him an envelope that said, best do the honorable thing and end it now, essentially encouraging him to kill himself, or they would expose the information. And this happened right in the United States to a radical who turned out to be right. Okay, there are three special dimensions of intellectual privacy I want to talk about. The first of them is thinking. So what is this girl thinking? Well, we don't know. We could ask her, and this is a map that my son drew of the things that not in response to, I need a slide for my talk, Declan, so please do this. He went away one day and sort of came up with this. And you have lots of important things like soccer and football and Star Wars and reading, awesomeness. And my favorite part is between screaming and awesomeness is stupidness. And a very little bit of sleep, and my son will know that he does not sleep. We also have Google, right? That if you think about every search event in Google, think about everything you have wondered about, right? The transcript of your search history is a transcript of your wonderings, of your fantasies, of your predilections, of your interests. It is very close to a partial transcript of the operations of a human mind, and this is the kind of thing that we should protect, right? Google itself recognized the fact that web browsing is thinking. As an ad, used to run some ads for Chrome, browse the web as fast as you think, because browsing in a real sense is thinking. Second element is reading, right? What is this woman reading? Well, if it's an e-reader and it's on the tube in London, it was probably a few years ago this book, which owes its success to the privacy afforded by e-readers. As E.L. James, publicist, said, people don't know what you're reading on the tube. It could be anything on a Kindle. There's a privacy, which is wonderful. Of course, the problem with that argument is while there is an illusion of physical privacy, Amazon knows everything you read, all of your books, how long you've read them, what you highlight, what you did read, what you didn't read. And that data is subject to very little legal protection, even when it is on a Kindle. When this happened to Robert Bork in the 1980s, when his video rental records were disclosed by the Washington City paper in this article, Congress passed the Video Privacy Protection Act, which treated the records of one's video rentals as confidential. We should do something similar with data. Reading matters. My daughter said this. She said, well, what's your book about, Daddy? She's now 11. And I said, well, it's about intellectual privacy, and I gave a slightly less boring version of the version I just gave to you. And she said, oh, well, that's brilliant. That way me and Declan, her brother, my son, can read inappropriate books. And they can't read inappropriate books now, which is exactly right. That reading inappropriate books is the very essence of freedom of thought, of a free mind, and of a free society. Final special element is confined. This is Roy Olmsted, a famous bootlegger, out of whose prosecution the idea that the Fourth Amendment applies to telephone conversation. If you get a warrant before you listen to someone's phone calls, also incidentally a Brandeis opinion. This is Smiling Bob. He used to be on TV advertising Enzyte, the natural male enhancer. There was a case in the Sixth Circuit a few years ago which raised the issue of whether emails are protected by the Fourth Amendment, whether you have to get a warrant before you obtain emails. In the Sixth Circuit, in the Smiling Bob case, turns out the Enzyte didn't work, and it was a scam, and he was investigated for fraud. In the Smiling Bob case, the case called Warshak, which is the name of not a That's not Bob's last name, it's the name of the owners of the company, Berkeley Nutraceuticals, which produced Enzyte. It held that if the police want to obtain emails, they can't just ask, right? They can't just have a court order. They have to get a full warrant supported by probable cause. And more recently, the Supreme Court, in the Riley decision last term, seems to be coming along to this way of thinking, right? And holding that in a search incident to an arrest, the police have to obtain a warrant before they can search your mobile phone. They can't just pat down your mobile phone and read everything on your digital diary the way they can find everything else that's in your pockets. Okay, so what should we do? First of all, we need to think beyond Tor privacy. We need to realize that Mabel Warren's elitist fantasy is not the only way to think about privacy, and is not the way we should be building our privacy rules for a digital network 21st century. More importantly, we should protect intellectual privacy through law. We need a series of rules. We need to update our law to reflect our new technologies. So that our technologies don't dictate our liberties, that our liberties inform our technologies, rather than the other way around. Now, you might say at this point, intellectual privacy, that sounds like academic elitism. It sounds like something for people who live in ivory towers, like you, Richards, who sit there stroking your goatees while your pointy head pokes out of the window. Now, I don't have a goatee. My head is big and round and melon-shaped. It's not pointy. But more important, intellectual privacy, we don't think of intellectual property as being only for intellectuals. Intellectual property is for everybody with an intellect, everybody who thinks. Arguably, that should be every. These, as Steve will know, these are not my children, believe it or not. These are my friends' children. But I do love Romy's thumbs up sign for intellectual privacy. And I was going to say they weren't put up to this. I didn't put them up to this. Their dad probably did. Okay, we need to recognize that intellectual records, records of our thinking, records of our reading, records of our communications, are sensitive records. And we need to protect them greater than we do other sorts of information that we might collect, like records of what kind of toothpaste we like, for instance. We also need to reject the idea that privacy is binary, that privacy is on or off, private or public, known only to me and my heart of hearts, or shouted at the rooftops, in the words of Warren Brandeis, to the entire world. Right? Most information is somewhere in between. Most information has always been somewhere in between. Now our digital technologies are allowing us to capture more volume of information and more varieties of information. But that doesn't mean that the fact of capture means that privacy is over. It doesn't mean that the rules we need to regulate how the information is collected, how it is stored, whether it is stored securely, how long it is kept for, what uses it is put to, can be used, can beyond regulation or not. Right? Think even of Title VII, right, which bans the use of a piece of data, someone's race or gender, to make adverse employment decisions for them. Right? We regulate the use of information, even though for most people the race or gender is about the most public piece of information that one can imagine. Right? We can regulate information even when somebody else knows it. In fact, right, to a room full of lawyers, that is the essence of the attorney-client relationship. Right? That a client comes to you and tells you their secrets and says, "Well, you know, I may have killed someone. I'm not sure. Will you represent me?" The lawyer isn't then free to say, "I've got a first-round right to tell the press this." Or the lawyer isn't free to say, "Well, I might be able to sell this to marketers to get more money from you from them than I would get from you." Right? The idea is an idea of confidentiality. That information should be protected, not necessarily because of its nature in the first instance, but because of the relationships in which it is shared, in which it is used. And I think it's important to recognize new kinds of digital relationships in which we need to apply new notions of confidentiality. More fundamentally, problems of intellectual privacy, like all problems of human values and technology in a digital world, are too important to leave to just lawyers. We have to go beyond law to think about ways to solve this problem. We need new laws to protect intellectual privacy. We need to reform the Wiretap Act. We need to restrain the NSA. We need to place confidentiality rules on companies like Amazon that have detailed records of our reading rules, our reading behavior, our interests, our fantasies, our likes, our wonderings, our politics. But we also need to try to protect these values through things other than interpreting the Constitution or passing a statute or some regulations. I think the most important place to start is a notion of professional ethics. If you think about doctors, you think about lawyers, you think about architects, you think about priests, you think about psychologists and psychotherapists. These are informational professionals, and they have evolved a series of ethics of their profession, which go beyond, well, if I can sell it for more money, I'm going to. Right? They realize that their continued success depends upon the trust they establish between themselves and their patients or their clients. And they also realize that it's important not to betray that trust. Google, actually, so informational professionals now include engineers. They include data scientists. They include data researchers. They include the people that run the search engines and the social networks and the communications platforms. And Google started to develop a notion of professional ethics with its "Don't be evil." Right? This is the visual joke. "Don't be evil" was the official or unofficial Google motto. It still is. But this idea that information is power, and companies that have lots of information should use that power for good, and for public good, not to hurt people, is tremendously powerful. And then the first set of informational professionals who figured this out in this context are librarians. Right? Librarians have done tremendous work figuring out the ethics of information use and the idea that information custodians should use the information to benefit their clients rather than to sell them out, to betray them, to pivot and monetize, as the venture capitalists say, at the first available opportunity. Right? Librarians governed access to information, and they made a decision about 75 years ago that their job was not to edify and to coerce and to nudge people to being better Americans. Their goal was to empower people, to let people figure out what they are interested in, to help them. In order to do that, it required them to tell the reference librarian, I'm interested in communism, or I'm interested in Buddhism, or I'm interested in finding the second book in the 50 Shades of Grey trilogy from the library, please. But it required that trust and required confidentiality. And librarians developed in 1940 the Library Bill of Rights, a series of principles, in particular freedom of inquiry and also privacy and confidentiality of user records, which I think is a useful model for information professionals to take. The information is shared by people not because they want to give it away, not because they want to be betrayed, or because they have a particular purpose they want to accomplish, whether it's sending an email or ordering a book or finding a particular website or researching something. And the information should be used by the intermediaries for that purpose. But then, absent real consent, it should not become a business asset of the corporation any more than client confidences are a business asset of lawyers they can discharge in bankruptcy, or patient ailments or something that doctors or dentists do. We need to develop a sense of ethics, and companies have started to begin to compete on intellectual privacy. The Mozilla browser is built around a series of privacy principles, no surprises, real choices, trusted third parties, limitation of data. If you care about privacy, first of all, don't buy a Lenovo laptop because they're apparently, we learned this morning, they're spying on you. And second, I think Mozilla is the best company on privacy. Apple's also quite good now, since they've realized they're a data company, they're a device company, and they can make plenty of money selling things that are jacked up in price because they're brushed aluminium covers. They don't need to be in the rapacious data trade the way Facebook or Google, which don't actually sell anything other than your eyeballs to advertisers, are able to do. There's also a search engine, DuckDuckGo, which does not track you. It's almost as good as Google, but that is a function of it's not quite as good as Google, not because Google's surveillance-based search is better, but because DuckDuckGo doesn't have the number of servers that Google has. But DuckDuckGo is a perfectly good search engine. It's an example of companies trying to compete on on privacy. And finally, the way companies operate, right, is the way they ask questions of whether you want to have your intellectual privacy infringed. We want to implant an RFID tag, and no, that's horrible, but wait. It's a camera, and it's an iPhone, and an MP3 player. Oh, that's wonderful, that's great. And I think this kind of nudging, this sort of whittling away at our privacy, even if the gadget is cool, is the kind of thing that in the long run will produce an internet, a society that was not the one we thought we were building in the first place. The way that the dogs of 2015 are deeply saddened and have had their illusions shattered from the optimistic, privacy-embracing internet dogs of 1993. Ultimately, I think this is the point, and Zadie Smith, one of my favorite novelists, puts the point well. He says, in the Anglo-American world, we race ahead with technology, and we hope the ideas will look after themselves. Well, the technology is racing ahead. We need to think about the ideas we want to have in that technology, the ideas that we want to build through design, we want to build through law, we want to build through professional ethics. Otherwise, we will build the kind of society that we don't want to have, and we would not have wanted in the first place. But I think the most important thing, at least the thing that I'm currently campaigning for, is that when we build these technologies, it's very important that we have intellectual privacy. So, thank you.
Okay, we have about 15 minutes for questions. Let's just
Everybody's convinced. Well, nobody's left, so that's a good sign.
Anybody?
Okay, I have a question about, because we're librarians, and I wonder how would you, as a library professional, go forward from here? I mean, what are some of the, because one of the things we've discovered in doing this work is it's really hard to convince the general public or even librarians that this is important.
Right, you guys just aren't cool, right? You have this, you have an image problem.
Well, and it's just I don't know, a lot of people still find this boring, I would say. It's hard to make it real. I mean, the Snowden revelations, when everybody found out that their cell phone records were being surveilled, that kind of hit home. But
yeah, I mean, so I think it depends in what context you're talking about. So, right, so library professions in libraries, like campaigning for intellectual freedom, campaigning for access, campaigning for the expansion of public libraries. People used to say, well, we don't need libraries anymore because we have borders. Well, guess what? There's no borders anymore. And Barnes & Noble is on life support. I think the importance of, the values that you've established on your own turf it's supremely important. And to keep campaigning for public access to libraries. I think what we probably need, I just sort of had a thought about this, that the reason we have this vast system of public libraries is in large part because one of the robber barons of the last great revolution, Andrew Carnegie, endowed a whole bunch of libraries. And I think perhaps that kind of a campaign, right, targeting, Bill Gates is sitting on an awful lot of money he wants to send out for the public good, and Bill Gates is also fairly pro-privacy, right, because Microsoft sells things, it doesn't sell data. I think obviously money is important, advocacy is important. I think the work that the library community did in opposing the Patriot Act, particularly, right, the so-called, I know you know this, Barbara, but the Section 215, the so-called library record provision of the Patriot Act, those sorts of things are important. And I think that the ideas that librarians developed, we need to make more public because they are rooted at bottom in trust, right? Librarians are one of the most trusted information fiduciaries, right? People make jokes about lawyers. They don't trust their data companies. They hate their cable company. They mostly like their doctors and their vets. But no one makes jokes about librarians except maybe that you guys are boring. So it's hard. I'm sure we'll talk about that offline as well. But it is difficult. But I think the campaigning work that you guys are doing and maybe finding access to resources to make that work even more powerful would help. I know it's not really nice to go find some money.
No, it's
Right.
just, an example is, I went to a local high school here on the west side of Chicago. And it was the librarian and the journalism professor wanted the kids to learn about privacy. So I started talking about the problem, since it was an African-American audience, 100%. I started talking about the apartheid in South Africa and how computers kept track of what people's racial makeup. There were, I think, 11 or 12 categories. Kids' heads are on the desk. They don't care. They were born then. But when I started talking about how the Gap knows what size blue jeans you wear, every head came up. They really cared about when they buy stuff at a store, that data is stored. And it just was a lesson to me about but it's really hard to get people to care about this, is what I'm getting at.
Yeah, privacy is a lot like environmentalism, right? That
Okay.
people do, it's a very so AT&T this week has they wanted to do what Lenovo was doing and monitor all of your web surfing to serve you ads, and a bunch of my friends. I'm taking no credit for this. I just have cool friends, I suppose. Campaign, they said no, you can't do that. You can't surveil you. And so AT&T said, oh, that's fine. We're gonna have two options. We're gonna have the privacy option and the non-privacy option. And the privacy option costs $29 more a month. And no one's going to buy that. Not because they don't care about privacy, not because privacy is not worth $29 a month. It's worth a lot more than that. But the benefits are diffuse. The benefits are long-term. The benefits are hard to reduce to money. And so we make these choices in using Kindles or accepting the privacy terms of a Kindle because it has a bigger book selection than some of the other ones, or it's easier to do because we already are on Amazon Prime. We make, the same way we, might throw one of these away, and we don't realize, right? There's sort of a swirling mess of plastic in the Pacific the size of Texas, or maybe the size of Australia. I don't know quite how big it is, right? That privacy is a lot like environmentalism, and the same dangers are there. Unfortunately, the same problems of advocacy. We need to have, unfortunately, things like 3 Mile Island, and things like melting ice caps, and things like the winter that everybody is currently experiencing, to make people realize that climate change is a problem, and the way humans interact with the world can affect that. And I think we need, we also need our Silent Spring. I don't think Citizen 4 is Silent Spring. Snowden might be Rachel Carson, but we need more of that, right? We need to be able to counteract the highly paid, very slick, very trendy, sans serif font-based marketing power of Silicon Valley, of companies and individuals who can make vast fortunes, essentially digitally strip mining our data, and having no attention for the consequences of what kind of society we're building.
Any other questions? Good question. So your solution, your key principles sound very consistent, or especially the first one, very consistent with the U.S. constitutional law and U.S. emphasis on freedom of speech. I guess I just wonder if your principles are meant to be for the U.S. only, or if it's meant to be universal. And if it's meant to be universal, I guess my question would be, well, how do you convince other countries like in the EU where the balance might be different, the balance they strike between access to information and privacy might be different. So what is it about the principles that you think would justify a more international application versus just being a very US-centric approach?
Right. Well, it's wonderful as an Englishman being accused of being US-centric. I have lived here longer than most of my students at this point, but I would say that certainly the first principle is consistent with what I think are the best traditions of American First Amendment law. I think that the American First Amendment law, as you know, is under assault. That everything should be regulated through the First Amendment. And there are people who believe that even my arguments that we should regulate Kindle data violates Amazon's right to speak, to disclose the data. I talk about this in the book. So it is a modified version of the U.S., but it's certainly broadly consistent with at least what sort of established First Amendment scholars in America believe. When I go to England, I get accused of being too American and of hating privacy, which I think is deeply ironic. Because in America, I get accused of being too European and of hating the First Amendment because I do want a cabinet to deal with these issues. I think the arguments are most resonant in the sort of G7 countries. That I think when you apply Western industrialized digital concepts to other societies, other values, it becomes more difficult. But at least sort of within the U.S., Canada, Europe, and some of the English-speaking countries in the Southern Hemisphere, I think I do get pushback from people who say, well, privacy against the press is so important. We should restrict the ability of these media conglomerates to inflict harm. But on the other side, on the data protection side, on the intellectual privacy, I think the argument is highly resonant with the rest of the industrialized or digitized world. I think it's only in the United States where there isn't a general law regulating basic principles for how our information should be used and setting up notions of sensitive data. Now, intellectual privacy is relatively new as an articulated concept. Its roots are ancient, right? Freedom of thought, freedom of conscience. So it's a fairly easy sell. When I talk about this in England and Scotland and in the Netherlands, and they usually, at least people who come to my talks, are very enthusiastic about it. But I think also the law in those areas, in those countries, is more protective of privacy than the US, where we tend to talk about innovation as if it is this sort of magical activity. I know there's one place too where I think we need to be careful in the United States that the First Amendment is sweeping too broadly, and that's in the area of revenge porn, which I talk about in the book, but didn't have time to talk about in the talk. I think there is no serious First Amendment. So this is the problem when I've been told that kids today have mobile phones and that kids today have sex. And sometimes when they have sex, and their mobile phones are on and they're recording what's going on. I take pictures. It's an age-old problem, right? But the problem of a breakup followed by the disclosure of these videos and images to third-party sites is a real problem. And there are a number of prominent First Amendment lawyers, practitioners, who argue that any regulation of the problem of revenge porn is unconstitutional. And I think we need to be careful about both about freedom of speech and about both privacy. We need to figure out much more carefully what we mean when we say those words and why we care about those values. Because if we don't, we're going to be unable to talk to each other, and we're going to be unable to figure out exactly what values should inform our society. Now, I will also say, as a final point, I think different societies can strike this balance in different ways. But I think it is essential for any society that wants to call itself a free society to have both a broad commitment to the idea that people should be able to govern themselves, and the free flow of political and cultural information must be maintained because of freedom of speech, and also that all people, if they are to govern themselves, if they are to call themselves truly free, should have a modicum, and more than a modicum, of privacy, and not just of their persons, houses, papers, and effects, to use the language of the Fourth Amendment, but also of their minds and their reading and their communications.
Yes.
I have a brief question. I really like your comparison of professional ethics, but with doctors and lawyers, and I think accountants too, there's a natural enforcement or regulatory body. So one of the, I guess, like the issues I have with that is just how can you enforce, like my firm represents a lot of advertisers, and so advertising companies, they want to do tracking and do PS, and there's some restrictions on that, and there's some best practices. There's no real enforcement or stick other than maybe public outcry or perception. And I was just wondering if you have any thoughts on how professional ethics enforcement could evolve over time.
That's a great point. And I think it goes back to Ed's question about the U.S. and the sort of absence of a formal privacy regulator. I think that before I get to ethics, at the level of law, right? As you know, there's the Federal Trade Commission, which has sort of moved into the vacuum of the fact there is no privacy regulator in the United States. And the FTC has been very active on things, it has jurisdiction over unfair and deceptive trade practices. So things that are deceptive, like companies say one thing in their privacy policy and then do something else, the FTC is going to get up in their face in a hurry, and they have settlements against both against Google and Facebook and many other leading internet companies, which place additional regulatory requirements on them, which I think then help build this idea of professional ethics. I think they've also been active in security, because the security of this information is important. And they're starting to develop a notion of unfair practices. But at the level of professional ethics, I think more regulation can help to coalesce those professional ethics. I think we need to be a little more critical of the magical thinking that we use that surrounds words like innovation and disruption. Yes, Uber may be cool and disruptive. This is beyond intellectual privacy. Though Uber did threaten to disclose the records of any journalists that disagreed with it by making all of their rides of shame public. You don't have to go very far in any data area before you get to intellectual privacy. But Uber is disruptive, but what happens to all of the taxi drivers? What happens to sort of, the quality of service you get, say, in New York or in London, where there are, generations of safe, trusted intermediaries? What happens to the people when Uber creates driverless cars, which it's investing millions and millions of dollars in doing to cut out the middleman of the driver? I think that we need to be more critical of the idea that something that is new is inherently better, and something that is disruptive is inherently better. And I think we need to create incentives, maybe ethics classes in engineering school. That sounds a little pie in the sky, but it used to be that one of the most ethical information professionals there were, maybe they weren't professionals, but the most ethical groups were hackers, right? In the 1980s and 1990s, hackers had this wonderful ethos of what was a good hack and what was a bad hack, and I fear that the ability to rapidly make fortunes has enabled engineers to get away from those ethics. The good news is, I think it's already happening. I think that companies are starting to hire chief privacy officers. I think the relationship between security and privacy, the problem of data breaches, makes companies like Lenovo this morning being only one of hundreds of thousands of examples, that there is a real business interest in behaving ethically with people's data. And it's one thing to make a quick buck through strip mining. It's quite another to create long-term, sustainable, trustworthy relationships between users and the intermediaries. And I think companies like Apple, which is talking about encrypting, data at the disk level, Microsoft, which has very strong privacy settings, right? It puts I was with the Xbox people recently, and they have a video camera that points at your sofa in your living room. Right? The Xbox Kinect is an infrared video camera that looks at your sofa. And the way they build those technologies is they store the data at the Xbox level rather than in the cloud. I think it's difficult. Advertisers, we may just need to regulate them because they have atypical incentives. But I think also the lawyers that represent advertisers can appeal to their sense, even if it's not their sense of justice or ethics, their sense of long-term professional interest. And the long-term professional interest of a digital society is one in which we trust our technologies, because people will not use technologies and social systems they don't trust. And I think from that perspective, we need to work to promote trust, and I think things like intellectual privacy are an essential element of any kind of trusted free society that at least that I would want to live in.
Okay, great. I think we're out of time. Let's thank Professor Richards again for his excellent talk. Buy a copy of his book. We have it right here, and we'll be signing copies here. So the line.